Thank you. And welcome to everyone who's joining us. Today's session, we're at session number 4, and our esteemed group of mentors are going to be talking to us about common procedural and evidentiary issues during the preliminary hearing. We have 3 wonderful speakers, and they're going to be sharing a presentation. So I want to encourage you all to put your questions into the chat. They will be monitoring it, and if appropriate, they'll answer it as they're talking, or they'll wait until and group them together and get to them at the end of the program. I don't want to say too much about their backgrounds. I'll let everybody introduce themselves, but I do want to welcome Dana Welch. She was our former president of California Arbitration and president-elect of the College of Commercial Arbitrators and an esteemed arbitrator. We have Katie Connolly, who is coming from the law firm side. Dana is an esteemed arbitrator. Katie is coming from the law firm side. And Tuyana Molokhoeva, who is, you're still in-house.
Sorry, I was muted. Yes, I am. I'm
Yes.
in-house now.
So we're getting some different perspectives here, and they'll be sharing a lot about their career paths and how they got to where they are as they go through. So without further ado, I'll turn it over to our esteemed mentors. Thank you.
All right, Katie, do you want to introduce yourself just with a few more words, and then
Sure.
and I will.
Hi, everyone. My name is Katie Connolly. I am a senior associate at the law firm of Norton Rose Fulbright. I am based in San Francisco. Before that, I was based in Washington, D.C. I am in our firm's international arbitration group. My practice is about 50-50 international arbitration and then litigation. So I do federal and state court litigation. Sometimes that's arbitration related, enforcement of awards, discovery requests in support of international arbitration. But I also do just kind of your standard run-of-the-mill commercial litigation in the US. I am in my 9th-ish year, I think, 8th or 9th year of practice. And I am a graduate of Georgetown Law School. So that's a little bit about me.
Deanna?
Okay. Well, I'll pick that up. Hi, everybody. My name is Tuyana Molokhoeva, and I currently serve as a general counsel at Connolly Peak Research, where my focus remains still on arbitration and litigation, although I also oversee a range of other legal affairs. It's really wonderful to be here because mentorship and learning has always been central part of my own journey in international arbitration, and my career has always been sort of balanced between international arbitration and cross-border litigation. I've been able to work with both civil and common law systems. I've spent a significant part of my career practicing in Moscow at Brian K. Leighton Paisner, where I handled mostly investment and commercial arbitrations. And later I completed my LLM degree at University of Southern California and joined California State Bar. Alongside with Katie, we co-chair Young CalArb, where we work to support young practitioners like you and students who are interested in international arbitration.
So I'm Dana Welch. I've been an arbitrator for 22 years. I was the president of CalArb last year. It was the year that we won the ICA bid to come to San Francisco in 2028, which is very exciting for us. And I'm currently not the president-elect of the College of Commercial Arbitrators. I am the president as of this weekend. So
as of this weekend, fantastic. The website is not updated.
And I'm thrilled to be here because an very important thing to me is to help younger lawyers figure out what arbitration is about and how to succeed in arbitration. So that's what we're here for. So without further ado, we have a PowerPoint for you. We're kind of lose our faces a little bit. They're going to be on the side, but Tuyana is going to manage the PowerPoint.
Okay, let me share my screen here. So that's where we're going to start.
Right, so today we're going to be talking about the preliminary hearing. Do you want to go to the next slide, Tuyana? There you go. So the preliminary hearing is really the first thing that happens in the arbitral process. Can people put themselves on mute? Because we're hearing some background noise. It's the first thing that happens. And it's really the opportunity for both the arbitrator. You want to go forward a slide again, Tuyana? It's really the first opportunity for the arbitrator and for counsel to meet each other. So it happens after disclosures are made, after the appointment is confirmed. And I, as an arbitrator, always get the parties an agenda with what I want to talk about. I will know the case file thoroughly. The case file has been submitted. I will understand as much as I can from reading the papers. And I will prepare an agenda that I get to counsel. I will ask counsel to get me a joint conference statement with respect to how they want to manage the proceeding. But it really is the first opportunity, and actually the most important thing that happens in the arbitral process other than the evidentiary hearing, because it's going to set the complete roadmap for the proceeding from beginning to end. So Katie and Tuyana, how do you prepare as counsel for a preliminary hearing?
Yeah, it's quite an extensive process, I would say. To Dana's point, you are really kind of mapping out how you want what is best for your client throughout the entire arbitral process. So you do start, I think, exactly as Dana said, the most important thing is you are introducing yourself to the arbitrator and you're introducing your case to the arbitrator. So whoever is going to be speaking at the hearing needs to prepare kind of their introduction to the case. And so sometimes the arbitrator will tell you that they're going to ask for that. Sometimes they don't. But no matter what, you kind of have to have your elevator pitch ready. What is your case about? What are the critical issues that for your client? What's at stake? All of that, be clear, concise, and really know what is important and be prepared for that elevator pitch, whether they say it's going to happen or not. Then I think even as a more junior associate, mapping out your preferred schedule for the arbitration, when you want this to go to hearing, when the briefs are going to be, what the discovery process is going to look like, really taking every single part of that agenda that the arbitrator likely will provide, and coming up with your client's best case scenario. Then, and I'm sure Tuyana can talk about this a little bit, but then you're going to have to kind of negotiate likely ahead of time with opposing counsel, which is a whole other kind of tactical proceeding. Tuyana, I'll turn it over.
Yeah, just to add to that, I think it's really important to know which points, which items of the agenda you have the agreement with the opposing counsel and which you have not, and then have a clear understanding on what's your client's best case scenario for those items that you have not been able to reach an agreement with the opposing counsel, and then be able to really present your best case to the arbitrator, because that's where those items will be decided on. I think that's that was something that I wanted to add.
Yeah, the only thing I want to add is that as an arbitrator, I can tell how counsel are going to get along and whether they're going to be cooperative or whether it's going to be a very adversarial process. And the best thing to do in arbitration is to cooperate and act in a civil manner. And that starts with collaborating with your opposing counsel in coming up with a proposed schedule for the arbitration. All right, let's go to the next slide.
So, as I think we mentioned, the agenda for the preliminary hearing is often going to be set by the arbitrator. That doesn't always happen. I've recently had an arbitration where the arbitrator doesn't really provide an agenda and ask the parties to work together to come up with the agenda for the preliminary hearing. But I'd say most often now, the chair will provide some sort of outline of what they would like to see from the parties. This likely will then, whatever that agenda is, will then become kind of the procedural order that gets entered. So sometimes the parties are going to work together to draft that procedural order based on a template provided by the arbitrator, or sometimes that may come out of this preliminary hearing. It depends on the arbitrator's preference, but that's going to include a brief summary of the claims. Like I said, you may be asked to give an elevator pitch at that at the hearing itself. You're going to have to address whether there's any jurisdictional issues. If there are jurisdictional issues, you're going to want to preview them for your arbitrator and then discuss them. We'll go into that some more. You're going to want to deal with what the procedural rules are, what the seat or the venue is, if those are different, and what the language of the arbitration will be. You're going to, as we said, set the schedule, which is one of the most important things that's going to happen. And then you're going to deal with disclosure and an information exchange and what that is going to look like for your arbitration. So we'll go through each of these in more detail now. So I think we can continue on.
Okay, so the first one is jurisdictional issues. As Katie nicely outlined, it's one of the first issues that you would want to present and pitch to the arbitrator. So of course, the arbitrator will not decide on the jurisdictional issues at the preliminary hearing, but you might want to present the outline of those issues so that the tribunal could later decide on whether to bifurcate proceedings or not. So let's just walk quickly through the most common types of the jurisdictional challenges. So the first would be, of course, the scope of the arbitration clause. So the question you want to ask is whether the clause covers all the claims that are presented, and if of course, if the clause is narrowly defined and it covers only the contractual claims, and it might not cover the statutory or, for example, negligence claims, then it kind of makes it straightforward. But then, of course, it can become a matter of interpretation of the contract later in the proceedings when the arbitrator will decide on those. Then the next important point is whether there are all the necessary parties included in this proceedings, and here you would want to consider if, especially in the multi-party cases, if there are all the stakeholders that are involved in the dispute are signatories to the to the arbitration clause, and then of course if there are some non-signatories present, then it creates a separate issue here, and here the tribunal will often decide on whether those necessary parties are that are not currently present in the proceedings must be included, and again, this will be a matter of further consideration. But if you as a counsel see that there is a third party that is not currently in the proceedings, you would want to raise this at the preliminary hearing. And the third issue that often comes up is, of course, arbitrability of the dispute. And here, for instance, as you might, of course, know, many jurisdictions would restrict arbitrations for certain claims, such as criminal cases or antitrust matters. And if you see that some of the claims are related to those issues, then it can create also another jurisdictional challenge. Those are typically the types of challenges that might be raised at the jurisdictional stage. Now, like I said before, all those issues you would not need to argue fully at the preliminary hearing, but I think the scope of the issues and the depth and, of course, the likelihood of whether those issues will succeed will help the arbitrator to decide whether they want to consider those issues separately, such as to bifurcate the proceedings into procedural and the merit stage, or to consider those separately, to consider those together. And other factors that affect that decision would include whether the issues that jurisdictional and the merits issues are interrelated, and whether it will be more procedurally efficient and save time for counsel to consider those together or separately. And here, as a counsel, of course, you would want to decide what's the best case scenario for your client. Like, for example, if you are the party who is raising the jurisdictional objection, then most likely you would want the bifurcation as well. So you would want to be ready to present why the bifurcation is needed here. And on the other hand, if you are the opposing counsel who is defending jurisdiction, then oftentimes, although not necessarily always, you would want like uniform proceedings without bifurcation, and then you would want to present your position before the arbitrator as well. And why this is important is because it can affect the schedule quite significantly. It affects the schedule of the briefings. There will be a separate hearing on the jurisdiction if the proceedings is bifurcated, and therefore the overall time frame of the proceedings will also increase.
Can I add a couple of points, Tuyana? I don't know. Are you finished?
Yeah, of course. Yeah, that's it.
So I want to know right off if I have jurisdiction. And I don't want to proceed in a case unless I know that I have jurisdiction. So it's actually the first thing that I deal with. I ask, does anybody have any objections to my jurisdiction? And somebody pops up and says, I do. Then I set a briefing schedule and nothing happens until that's resolved. The other thing that I want to comment on is the question of who decides. Do the arbitrators have the authority to decide their own jurisdiction? In most cases, the answer is yes. And if in the arbitration agreement, a institution's rules are incorporated, most courts have said that grants the arbitrator the power to rule on his or her own jurisdiction, because most sets of rules include that the arbitrator has the right to decide on their own jurisdiction. Important exception, non-signatories. Arbitration is not a proceeding in court. It is a proceeding pursuant to a contract. So if there are parties that have not signed the contract and who are non-signatories, then virtually every court has said that's not up to the arbitrator to decide, it's up to the court to decide. Okay, procedural rules and applicable law. Let's get back to that slide, Tuyana. So one thing that we have to emphasize is the agreement. Everything in arbitration is governed by the arbitration agreement. So usually the arbitration agreement is something that's thrown together at the last minute when people are drafting contracts, but it's what rules. And an arbitrator has to adhere to what's in the arbitration agreement. So what I will do in my agenda and at the preliminary hearing is I'll look at the arbitration agreement and I'll say, do the parties agree that the arbitration agreement sets forward the procedural rules of ICDR, ICC, whatever it sets forward, and that's going to govern how we conduct the arbitration. It's going to govern what are the evidentiary rules. It's going to govern what are the rules with respect to information exchange. It's literally going to govern everything in the proceeding. You're going to look at the procedural rules to determine what you can do. You confirm the application of any statutory rules, like the Federal Arbitration Act in the United States. What is the reason for that? When a party goes to confirm the award or enforce the award, they have to understand what statute they're enforcing the award under. And so a good arbitrator will say, what is the statute that we are operating under? You want to confirm whether there are any soft law that are soft rules that the parties want to consider, like the IBA guidelines on the taking of evidence, because these sets of rules don't answer all questions. And particularly when you're dealing with parties from different jurisdictions, maybe there's one from a civil law jurisdiction and one from a common law jurisdiction, the IBA guidelines in particular will point you to how to use those rules and what's the best way to approach it. But that's something that needs to be discussed at the preliminary hearing. Do you agree that we can look to the IBA guidelines? Are there any other guidelines that you want to be considered? And finally, what's the applicable law? We're talking about the substantive law. So is it the law of the United Kingdom? Is it the law of India? Is it the law of California? And that's going to drive how you consider the substantive claims, not the procedure. People often get confused and think if you incorporate or you say that California law applies, then we're going to get into the California Code of Civil Procedure. They're wrong. That's the first thing, is the procedural rules per the arbitration agreement will drive how the arbitration is conducted. Okay, let's move on.
Okay. So next, I think we're going to talk about what we in the U.S. we call discovery, but a disclosure or information exchange in international arbitration. So one of the key issues here is that the domestic arbitration in the U.S. is going to look very different than an international arbitration that may be seated in the U.S. Because U.S. discovery rules are quite a bit broader than a lot of other countries, most other countries in the world. And in international arbitration, you kind of tend to end up with some sort of mix between kind of the U.S. broad discovery and maybe a more limited discovery. But if you're going to be against U.S. counsel, you have to be kind of a U.S. A U.S. entity as an opposing party. You have to be aware that they may be pushing for more discovery than you, as a foreign company or foreign practitioner, may be used to as someone outside of the U.S. So just kind of be aware of that. And that is likely we're going to need to do is have an early conference with opposing counsel to really understand what they are envisioning for this arbitration in terms of discovery, so that you know kind of what the two sides are and what might be a middle ground. So of course, you're going to start with discovery scope and relevance, figure out, focusing on essential documents only versus kind of going on fishing expeditions. Think about, like I said, civil versus common law. Think about e-discovery. That's going to be a huge part of what you're doing nowadays. So whether you want to establish an e-discovery protocol right up front, what metadata is going to be disclosed, all of that kind of information. Whether you want to agree a confidentiality or protective order up front ahead of time, or whether you just want to say the parties can agree one if it becomes necessary, but you probably want to make some provision for that in your preliminary hearing and procedural order. Think about depositions, third-party discovery, or expert discovery. You almost certainly are going to want to include a provision for expert discovery. What disclosures have to be made and what information that expert has to disclose. Again, that can really depend, the rules for that can really depend on your jurisdiction. So, California State Court, you often have to disclose almost all communications with an expert. That's not the case in federal court, and that's often not the case in international arbitration. So including what information you are going to disclose and what information is going to remain privileged in your communications with your expert is really, really important to set up that expectation up front and make sure the parties are agreed. And then, of course, dispute resolution. So you're likely going to be dealing with a Redfern schedule or a Stern schedule when you are dealing with disclosure requests. So that is a way for the parties to try to resolve disputes among themselves and then present any remaining disputes to the tribunal for resolution. But you may want to think about what other types of discovery disputes may arise. Are you going to need a physical inspection of the site at some point? Do you need to decide that protocol now, or do you just need to include something in your procedural order so that if a dispute arises as to that site inspection, you can go to the tribunal for resolution? Start to think about all of those potential issues, what you need to decide now, and what you need to include a provision for potential decisions later on.
So Katie, can you describe what a Redfern schedule is for people?
Yeah, so a Redfern schedule is essentially a chart. The first column in the chart is what's going to be filled out at first. So that is where you are going to put your request for disclosure. So you have the first column is your request for disclosure, and you can have as many rows as you have requests. So let's say you're going to have 20 requests for disclosure. You're going to have 20 rows in your Redfern schedule. Then you send that Word document. This is outside of the tribunals. This does not go to the tribunal, it just goes to opposing party. But you send a Word document of that chart with your first column with your disclosure and then 3 blank columns after it. You send that to the opposing party. They then put their response into the second column to each of those disclosure requests. So they can either, actually, I am wrong, I'm so sorry. The second column is your justification for your disclosure request. So you're going to put in why you need the information and what legal basis or procedural basis you have for requesting that information. Then the third column is the opposing party's response. So they can either say, yep, we agree to produce this, or they can say, no, we object, and here is the basis for our objection. Fourth column, you do get a chance to reply. So you can go back to the opposing party and say, you are incorrect, you need to produce this information, or we agree to limit our initial request, see if we can come to an agreement on it in some way. The parties may confer a little bit further, but that is kind of the substance of the Redfern. You have the disclosure request and the support, the opposition, and a reply. And then that, for any disclosure requests that are left unresolved, where the parties were not able to reach an agreement through that process, then that Redfern schedule with those requests go to the tribunal for resolution. So your final column is for tribunal resolution. You may or may not have a hearing in front of the tribunal. Usually you probably will have a procedural hearing unless it's kind of a very simple dispute. The tribunal is probably going to want to hear from the parties as to the disclosure request. And then the tribunal will decide. And that Redfern schedule is intended to be kind of a comprehensive overview of the disclosure process so that you have all of the information you need in order to know what is being disclosed or not disclosed in a single document.
Yeah, I just want to add to that in addition to the Redfern schedule, I, as the arbitrator, will always tell the parties what my discovery dispute resolution procedure is outside of that. And it usually consists of meet and confer, talk to each other, have a meaningful meet and confer. Don't just send nasty emails, but actually talk to each other. And if you reach an impasse, then send a written joint statement to me within a certain amount of business days. I can usually resolve things on the papers. If not, and I think that there's some kind of compromise that's available, I'll call a Zoom hearing. But it's very important right at the outset in the preliminary hearing, not only to establish the Redfern schedule or the Stern schedule, but also to get from your arbitrator, how do you want to resolve disputes? Okay, next slide.
Okay, so now briefly on dispositive motions and also interim status conferences and final conference. I will start with the dispositive motions. So what is a dispositive motion? Essentially is a tool that allows to finally dispose of some or all of the legal issues that are clear-cut and are straightforward, and there is no need for the final hearing on the case. So this tool really is not something that has always been present in international arbitration, I would say, because most of the rules that, for example, the Singapore rules or Hong Kong rules only introduced those in around 2016, I think, or maybe 2018 even. That's it's just something that I remember from, it was not there at the beginning of my practice. Those of you who have practiced in the common law jurisdictions, of course, know that they are essentially can be compared to a summary judgment motion or a motion to dismiss. They, for those motions, if the tribunal normally would establish a schedule also to file any dispositive motions that the party would like to file. Some of the rules would allow, would set a special procedure and would require a permission from the tribunal to file such a dispositive motion if it hasn't been decided previously, for example, at the preliminary hearing. So why those motions can be useful is if there is a claim that is manifestly without merit or manifestly outside of the jurisdiction of the tribunal, let's say, there is a party can argue and have faster resolution of the dispute than the regular procedure. So, but of course, the threshold for those is quite high, and that's why there is a special procedure that is normally prescribed in the arbitration rules that are applicable, or applicable statutory rules, for example, the Federal Arbitration Act in the US. Now, and apart from the preliminary conference, of course, there might be some interim conferences where essentially the tribunal will track the process, the case progress, and the parties can raise some issues that don't necessarily require a motion, but would need the resolution from the tribunal. And for example, some matters that that counsel had disagreement between themselves and need the tribunal to step in. Any evidentiary, like for example, if additional discovery, additional disclosure is required, and there is a disagreement on that can also be decided in those interim status conferences. And the final conference is like a pre-hearing conference where just the purpose is just to confirm that everybody involved is ready for the final hearing, and there is a witness list. There is they have everything essentially set up for that.
Yeah, so at the preliminary hearing, if you have a good arbitrator, they're going to set this entire schedule. They're going to say, I want an interim status conference. I usually set mine 60 days before the evidentiary hearing. I have my final status conference late, usually a week or two before the hearing, and it's because my observation has been the counsel are not ready to talk about what's going to happen at the hearing. And I will get out an agenda that instructs people, here are the things we're going to talk about. And it's typically, what rules of evidence are we going to use? And in arbitration, as people know, that there's no adoption of evidence. What's going to be the order of witness? How are we going to manage time? How are we going to handle documents? Are there going to be opening arguments? Are there going to be closing arguments? So it's really critical that this final status conference happens, or else you get there the first day of the evidentiary hearing, you basically have no idea about what's going to happen. Okay, ready to go to the next slide?
Okay, I think that brings us to the key takeaways on a preliminary hearing. So the first kind of purpose of a preliminary hearing is to ensure procedural fairness for parties in different jurisdictions. So, this is the opportunity for everyone to come together and agree, or at least to understand if you are going to be ruled against in a dispute, but at least to know the expectations for what is going to come out of this process. So you have an opportunity as counsel to advocate for your client, and everyone will kind of know how it's going to proceed.
Right. So what that means in particular is I'll give you an example. There are different rules with respect to privilege for different jurisdictions. Some jurisdictions, for example, say that in-house counsel don't have any protections. No, it's not. They don't have attorney-client protection. So what happens if a document is produced inadvertently? Well, somebody from a country that didn't have that would say it's fair game. What if there's a person from the United States or a party from the United States where the in-house counsel is covered by the attorney-client privilege and wants that document back? That was their inadvertent production. That's why it's important at the very beginning is, how are we going to approach issues of privilege? How are we going to approach questions of information exchange? How are we going to approach questions of dispositive motions? Those kinds of things really need to be addressed right up front, and everybody needs to be on the same page to have a uniform approach to the process. So the next is define a clear roadmap. I basically map out every single thing that's going to happen in the arbitral process. Now, there are unanticipated things that come up, but you need a complete schedule and you need to map out absolutely everything. Otherwise, basically, people don't know what to do. So Tuyana talked about dispositive motions. I will ask at the preliminary hearing, is anybody intending to file a dispositive motion? If they are, I'm going to build out a schedule for that. And I'm going to ensure that that schedule is not jammed up against the evidentiary hearing, because you really need to know what you're going to be adjudicating in the evidentiary hearing. Okay, Tuyana, do you want to take the next couple?
Yeah. So I think, the other important point is to outline the protocol for resolving any conflicts related to the information exchange. And as Katie pointed out, when she was covering that information exchange part, is that in every it has to be, of course, their counsel should strive to resolve any conflicts and to reach an agreement. But in case there is any conflict, and in most cases there is at least some disagreements on the schedule, on certain information requests, there must be a clear protocol for resolving those disagreements, and you have to decide on that at the preliminary hearing.
I'll take the next one because since I'm the arbitrator here. I start with explaining to counsel before we open up the claims and defenses. I always ask for a summary of claims and defenses, but I'll start by saying this is a party-driven process, and whatever you agree to, I'm fine with. But I've been doing this for a long time, and I can help you make the arbitration more efficient. I can help you resolve disputes, and I'm going to manage this process. So when we say establish your authority, I establish my authority, I believe, by knowing the case file as well as the parties, as well as I can, and by really being very, very prepared when I come to the preliminary hearing. And particularly as a woman arbitrator, I think it's very important to demonstrate that I have control over the process. How about for you as counsel, Katie? What do you do?
Yeah, so I think as we mentioned in the beginning, one of the first things you're going to do is establish your credibility with the tribunal. So when you go to a preliminary hearing, you have to be prepared. Treat it like you are, before a judge in the local country or in person before an arbitrator. So imagine being in the same room. You're going to be fully, properly dressed, formally dressed for a hearing. And you're going to be prepared. So come in with that pitch ready about, like I said, about what your claims and defenses are, be prepared to give that no matter what, and really have an in-depth knowledge of all of the open disputes between the parties on any of the procedural issues, and also the agreements between the parties, so that any question that comes from the arbitrator, you're prepared to respond to it. And then the second part is, it's advocacy. You are advocating for your client's position. So whatever is going to best serve your client's interest in the case, use this time to advocate for that, whatever that may be. If that's a lot of discovery, you're going to advocate for a lot of discovery. If that's really narrow discovery, then advocate for really narrow discovery. But know what that position, be clear on what that position is, and be clear on how best to achieve that. So you will have already negotiated with counsel, with opposing counsel, going into this, but treat it as a true advocacy opportunity on your client's behalf.
And I'd like to add here, combining my in-house counsel and counsel perspective is, like it says here that structure the arbitration for your client's best advantage. But what really means is really understand what your client's best advantage would be, because sometimes in some scenarios it's not very clear, or especially on the points that there hasn't been an agreement yet before the preliminary hearing. For example, a seat of arbitration, something that you would discuss at the preliminary hearing. You would want to discuss with your client in advance what the options are and what potential scenarios would be, so that if there is an agreement that is reached at the preliminary hearing, you would make sure that it aligns with the client's expectations as well. And this applies to all other issues, of course, too.
All right, I think we're ready to take questions if there are questions, and maybe you can take the presentation down, Tuyana.
There is one question in the chat if we want to go to that one. I'll read it out loud to start, and then we can see if he wants to answer. But it's, how do you best deal as a counsel and as an arbitrator with a situation in which one party constantly invokes the local procedural rules which are not applicable to the arbitration? So I'd say, as a counsel, I would say generally that the way in which this is going to present itself usually is the opposing party is going to ask you for something that they are not entitled to. For example, say a deposition, and depositions were not agreed and they're not part of the whatever procedural rules were, procedural, evidentiary, whatever rules were agreed, you're not entitled to a deposition. So I'd say they ask for that. Well, they can ask and you can say, no, we're not going to present anyone for a deposition. That wasn't agreed. It's not proper. And then they likely have to go to the tribunal to try and enforce that. So what you would then do as the party that is opposing the request is point out that they don't have authority to request it. It wasn't agreed in the preliminary hearing. And the tribunal should deny the request for the deposition. And that's basically it. I mean, usually because everything is agreed between the parties, they're going to have to ask for an enforcement of whatever the request is if you don't agree to proceed. Is that wrong, Dana, in any way?
No, that's right. But I think the important point is you always start with the arbitration agreement, and the arbitration agreement will specify what procedural rules, unless it's a very, very poorly drafted arbitration agreement. So the important thing about arbitration agreements is they're just like any other contract. They can be modified, but they can only be modified by party agreement. So if a party comes in and says, gee, I want to, use the procedural rules of the California Code of Civil Procedure because the seat is in California, look at the contract. The contract says ICDR rules, or it says the ICC rules, and those are the rules that are going to drive it. And your arbitrator is going to say, yeah, if the parties agree that you want to incorporate the California Code of Civil Procedure, you're free to do that. But absent party agreement, we're bound by the arbitration agreement, and those are going to be the procedural rules. When an arbitration agreement is silent, and that sometimes happens, I work hard to convince parties that they do not want to use court procedures. They are very contrary to the purpose of arbitration, which is to be efficient, economical, and fast. Any other questions? Or let me ask, did that satisfy whoever asked that question?
Yeah, thank you so much. I was the one that asked the question, And Dana, I thought it was really interesting how you mentioned that discovery dispute resolution mechanism. And the question was coming also from the angle that you mentioned there, that you come up with this procedure, parties should agree amongst themselves. If they can't, you step in. And I'm also asking that question because I see that many times in an arbitration, there's some discussions that the parties go over and over again through briefs that are very expensive, the legal fees. And I wonder, what do you think as an arbitrator, if, for instance, you could step in at an earlier point if the parties are debating, let's say, a wrong applicable law or an argument that is clearly not in line with what the parties agreed in the arbitration agreement. If you as an arbitrator could also step in sometimes and say decide an issue on a preliminary basis, or just guide the parties at an earlier stage so that they don't keep fighting over issues.
Well, that's what the preliminary hearing is for, Felipe. It is really to say, here's the rules we're going to abide by. Here's the substantive law we're going to abide by. Here's our dispute resolution procedure. And other than dispositive motions, I basically will tell the parties that I don't want any motions. I want things to be as expeditious as possible. If you have a discovery dispute, send me a letter, send me a joint letter, send me email, but no motions, no like file the motion, oppose the motion, because that really drives up costs. So you want to do things as efficiently as possible. What's wonderful about arbitration is it's a bespoke process. So you can figure out when you meet with the parties, the preliminary hearing is what are the needs of the case, what are the needs of the parties. But everything needs to be spelled out at the preliminary hearing. And when counsel come in later and say, but I'm entitled to X, Y, Z, and Katie used the example of the depositions, which I would get in court, you can say, here's what the parties agreed to in the preliminary hearing, here's what the arbitration agreement calls for, and unless the parties agree otherwise, that's what we're going to go with. So I hope that answers the question.
Yes, thank you.
Lundi has a hand up. I had a question in the chat that was asked, I think, a few minutes before, so maybe you could take that first. Okay. So the question says, thank you very much for sharing your insights. I was wondering how arbitrators can establish their authority. Yeah, well, let me ask you a question. If you appeared in front of me, would you have any doubts about my authority? It really is, and part of it is setting a tone, and it's being comfortable about being authoritative. And part of it is just being extremely knowledgeable about the case and well prepared. So, setting a tone and establishing an authoritative approach takes time, and it takes experience, and it takes comfort with yourself and your ability to manage. But let me ask counsel, let me ask Katie, can you tell if an arbitrator is authoritative at the beginning and not authoritative in a way dictatorial, but really you understand that this is a person who you can rely on to control the process?
Yeah, I think there's two things that kind of indicate pretty early on, to me, at least from a counsel side, how the arbitrator is going to proceed. One is whether the arbitrator proactively sends out that agenda or like a proposed procedural order in the beginning, and kind of how early they do that. And, because sometimes they come to you and they just say, parties agree, whatever the parties agree, I'll take, that's fine. But sometimes, and I think Dana, you kind of said this is more your preference of, they come to you with like, here is kind of what I want to see come out of this, not the result, but the topics and the things that I think need to be resolved. And so these are the things that I want considered that we're going to address in the preliminary hearing. And so that, to me, kind of establishes that authority right away, because the arbitrator is being proactive and telling the parties kind of how they want to proceed. The other point to exactly what you said is that knowledge of the case. If the arbitrator comes in to the preliminary hearing and is like immediately asking questions that demonstrate a clear understanding of the issues in the case, that to me establishes that authority right away. It makes clear that they are taking this incredibly seriously. They're going to invest their time in this matter, and they understand it. From the beginning, they are demonstrating an understanding of the issues in the case, and so that just immediately establishes authority.
Yeah, I've sat on panels where I have not been the chair and the chair does not send out an agenda, doesn't ask the parties to meet and confer and put in whatever agreements they have. And I think that the parties come into the preliminary hearing and really are skeptical about the authority of the tribunal. So I really want to reemphasize Katie's point. Okay, Lundi had a question. You put your hand
Hi
down.
everyone. Hi everyone. I'm audible.
Yeah, we can hear you.
Okay. So I think at the beginning, Dana mentioned that a collaborative approach between counsel is more preferred than an adversarial approach. So I would like to know what are the benefits and negative implications of each approach if they are in. And also, what does integrity look like for an arbitrator?
For the arbitrator or for the counsel?
For the arbitrator. Arbitrator.
Well, let's see. The benefits of cooperation is that people aren't going to get frazzled and upset. You know, I mean, it's stressful. So you want to minimize the stress. It makes everything a lot more pleasant and less costly. I've been an arbitrator in situations where people fight about everything. It drives up the costs for the clients needlessly, and it makes the whole process extremely unpleasant. By the time you get to the evidentiary hearing, people hate each other, and it makes it very, very hard. On the other hand, if you act civilly, there's no reason not to act civilly because you can really resolve your dispute a lot more easily. In terms of integrity, I think there's one word that really is important, and that is neutrality. And that is that an arbitrator can never demonstrate any bias for one side or the other. How do you demonstrate that? If a question is raised by a party or a counsel, even if you know the answer, even if I know the answer and I know how I'm going to rule, I always ask the other side for their perspective. I don't just immediately say, here's what's going to happen. So all the way through, all the way till the end, until the award is drafted and rendered, the arbitrator needs to demonstrate a lack of bias. And I'll ask Katie as well, and Tuyana, how do you feel about arbitrators? And is that what's critical to you in terms of the neutrality?
Yeah, Tuyana, do you want to go first on neutrality, and then I'll follow?
Yeah, of course. I think this question, it's an interesting, it's really like has so many aspects to this question. And I think neutrality is like, to me, it's whenever there is a conflict, you as a party, as a counsel, you would want an arbitrator to be able to decide, to have the authority to decide, and not without, let's say, sometimes there is, I think, the time efficiency, due process, neutrality are those all the considerations that can sometimes come into conflict, and you would want an arbitrator to be able to like not think in a way that deciding one way or another would let another party that in favor, which was not, the decision was not in favor of that party, let's say, and it would not allow that party to raise those neutrality considerations. So I think as a counsel, I would personally want an arbitrator who would, not consider that as an obstacle to decide one way or another. But at the same time, yeah, it's I don't know, it's tricky. What Katie, what do you think?
Yeah, there are a couple things that come to mind for me. So one, I think the disclosure aspect is really important. So, really early on for an arbitrator, they have to disclose all potential conflicts. And, I think kind of the general, what I got from our last California International Arbitration Week, I would say is arbitrators generally do try to be over-inclusive for a lot of things. They want to make sure they get credibility from the parties by disclosing all potential conflicts. so that there just is no question, everyone knows what's happening, what the potential relationships are. So I think the disclosure aspect is really important in the beginning, to establish that credibility and that neutrality early on. I think for me, kind of as a counsel, I really appreciate it when the arbitrator provides some sort of reasoning, even on kind of procedural and disclosure, evidentiary issues. It doesn't have to be an extensive reasoning, but instead of just saying, granted, not granted, providing a little bit of the basis of that for me helps to establish kind of the neutrality of the arbitrator by just providing the basis for the decision. And then, you have the thing of kind of throughout the arbitration, the arbitrator kind of remaining a little bit separate kind of from, parties and everything, just kind of keeping that slight neutrality from any counsel or parties and kind of, that is kind of, it's all about appearance. As annoying as that is, as an arbitrator, I think, and because that you're neutral, appearance really does matter. So I think from the counsel perspective, that appearance of neutrality is really important.
All right, I think we have time for one more question. And Simon, you have your hand up.
Hi, everyone. Yeah, thank you guys for this insight. And yeah, just leading off from their latest point, Katie, about appearances and stuff like that. I actually, this summer, was part of a school trip. We looked into like the energy transition and conflict resolution regarding it. We went to the UK and Aberdeen, and while we were in London in UK, we visited the London Maritime Arbitrators Association. We talked to one of the arbitrators there, and you made an interesting point that kind of spoke to how the arbitrators kind of ran the ship, so to speak, maritime. And you mentioned that when it comes to arbitrators, just in general, trying to set the tone, trying to make the proceedings as they wish, as they desire. They try to make sure that all the witnesses, all the non-party people who come in and give the testimony, they try to make sure they're all treated well. And they also try to make sure they are, the parties don't really get on them. And he did make an interesting note in saying that, sometimes American, I guess, arbitrating attorneys, like the counsels, they typically have more aggressive than like other ones out there. And so in context of like that, I'm just curious to know, like, if the arbitrators explicitly say, okay, guys, we're gonna play nice, we're gonna keep things civil, none of this adversarial stuff that you guys are so good at in America, we're gonna do it differently. So I'm just curious to know, like, in the international arbitration field, like, is that like one of the things that the arbitrators talk about in the preliminary phases?
I will do that if I have a sense either from the case administrator or from the preliminary hearing. I won't say it otherwise. But if I have a sense that people are going to be difficult, I will say something, and I'll say, we're gonna be civil to each other, and we're going to adhere to rules of conduct that are going to apply to all counsel. Katie, have you seen arbitrators do that?
Yeah, but I think too, part of it is just being a good international practitioner of like, we recognize that, like I said, I do both litigation, court litigation and arbitration. And I recognize that the lawyer I can be in front of a California judge is a different lawyer than I can be in front of a British arbitrator. Those are two different people, because it's just like when you're going to advocate in front of a jury. You have to know your audience. You're going to advocate to that, your client's best interest in front of the audience that you have. If my audience is a British and European tribunal, I am going to really tone down any adversarialness. It's going to be extremely polite. And also just, I am, as an advocate, not a person who's ever really rude to third-party witnesses in particular, or witnesses in general, but especially third-party witnesses. That I don't think gets you anywhere at any time. But yeah, I think part of being a good international practitioner is knowing your audience and being able to kind of change your advocacy style based on who you are advocating to.
I think that's a really good point.
Yeah, I think on that note, all I have left to do is to really thank our wonderful arbitrators and counsel today that were leading our session. That was a master class. I took some notes myself, and I really appreciate that. Appreciate all of the questions from our mentees. And we'll go ahead and adjourn. We're at time, and we'll see you back on November 12th for our 5th session on what do arbitrators expect from counsel during the evidentiary hearing. So we'll move forward in our life cycle of an arbitration proceedings. Thank you all so much for all your presentations and for all your attendance today.
Thank you.
Bye.
Thank you.
Thank you.
Thank you.
For joining us.
Bye.